evening and welcome to the Womxn Show on Cape Town TV. Now, social media has been buzzing over the past few weeks after a video surfaced of much-loved TV presenter Katlego Maboe confessing to cheating on his wife. And while opinions are divided, with some people thinking, it just happens, or it's not that serious, others are saying that it's unforgivable. Regardless of your opinion, what is much less spoken about is the fact that Maboe also had a protection order taken out against him for domestic violence in September 2020. And that's what we're going to be speaking about this evening. Now, the lack of conversation around protection orders tells me two things. One, there's still a lot of misconceptions around domestic abuse in South Africa. And two, we are not taking domestic violence seriously enough. Now, before we get into those conversations, we're going to have a look at a video where some shelter managers who work directly with victims of abuse speak about their problems accessing the justice system for protection orders. Let's have a look.
It was a struggle to see, it was a struggle to get police officials to firstly recognize the Domestic Violence Act, and work accordingly to the Domestic Violence Act. The same happened with the courts. Magistrates, they were used to giving so much attention to the Criminal Procedure Act that they neglected these other small acts like the Domestic Violence Act, the Children's Act. And I think it fell upon us working in this field to make them see that no act is more more important than the other act, because it boils down to the Constitution and the rights of people. So that was the fight that we had to fight, to get people to recognize these acts and do exactly what is supposed to be in this act. The same with even other stakeholders, that had a role to play, making the community recognize that there is help outside. There is acts in place. It's just that people are not implementing them correctly.
In 1998, South Africa passed the Domestic Violence Act, a product of Section 12C of the Constitution that states, everyone has the right to freedom and security of person. That includes the right to be free from violence. 20 years later, in 2018, while progressive on paper, implementation of the Act is problematic, with structural and cultural issues and perceptions often restricting or denying women access to their rights.
There was a case recently where a woman spent her birthday trying to get a protection order the day before her birthday, and she was killed on her birthday. Horrific, and that is part of the problem. Actually, we've got good laws, but they're not implemented, and the police don't actually come to the party because they don't arrest the perpetrators. We had one who found the house and was harassing us and making a noise. Police came and they said they couldn't take him away, but there was a warrant of arrest. So the police aren't properly educated as well about what needs to be done. And then we had a case in the office where a woman, her partner sent her a message to say that he'd got a protection order against her, and she said, no, she got the protection order. She sent him a message to say, I got the protection order. He sent the police to arrest her for that, and the police actually responded to that. So that was just completely ludicrous when women are being murdered, beaten, and to get the police to actually respond. It's unbelievable.
I think, if we look at not just SAPS, but all our structures, we speak of structural patriarchy. So we speak of instances where there's no understanding of women's issues, there's no understanding of what affects women and how certain things affect women. So when we talk about our structures now, we're talking about our government. If we go straight to the top, how many women are in the executive, how many women are in the legislature, and that's our representatives of of who we elected to be in charge. And then so when they take decisions, are they taking women's issues into account?
Women's abuse shelters provide a safe physical and emotional reprieve for survivors of abuse, and often fill the gaps between state departments to increase access and speed up service delivery for abused women.
At one point when I got here, people did not access the shelter because they did not want to go to the police in the first place, to lay a charge or to ask for assistance because they were always turned away. So that was one of the things that we had to do. I had to go physically to the police station and speak to the police, the station commander, and tell them that we won't tolerate people not being assisted at the police station. At the Department of Justice, we won't tolerate people having to wait a month for a protection order after having applied for a protection order. Those kind of challenges we have experienced. We started conversations with the station commanders. Conversations such as what is working and what is not working. And there were a lot of challenges because we also realized and we had to acknowledge the fact that the police officer, SAPs have their own challenges. Like there's not always a police vehicle able, on hand to bring a victim to a shelter. Not all the police officials, especially in the charge office, are properly trained when it gets to matters of domestic violence. So we had to start that conversation.
What do you think can be done to address gender-based violence in South Africa?
I think a lot can be done, and it starts with the children, because the most thing that I've learned being here is we're dealing with these women, they're being abused, and the children suffer more, and they go back. Some of them, not all of them, but some of them, and you can actually see the signs in the children. When the children are abused, children swear and they fight and those things. I think a lot can be done at schools, because most of us don't even know what abuse is. We always thought that abuse is like eating someone. We never knew that there was sexual abuse, there was like emotional abuse, like financial abuse, all those sort of things. Because abuse doesn't mean just to be eaten, you have a blue eye, and then it means you are abused.
Recently, I read a report, a research that was done by the Institute of Security Studies, and they looked at men who were incarcerated for 15 years and more from various racial backgrounds where they perpetrated extensive trauma and violence, and all of them grew up in abusive environment. And so that just gives you an idea that if we don't stop this cycle, it perpetuates into the next generation.
Those were just a few of the issues experienced by women's abuse shelters when helping victims of violence. After the break, we're going to be speaking to a number of stakeholders who are looking at the current situation, as well as some amendments that have been proposed for the Domestic Violence Act. But before we get into those discussions, let's also look at what is a protection order. The general perception around domestic violence is that it relates to physical violence, but the Domestic Violence Act recognizes a number of different types of abuse. This includes physical violence, sexual violence, emotional and psychological abuse, intimidation, harassment, stalking, property damage, and trespassing. And what constitutes a domestic relationship? It's not just a husband and wife. It's people who are married, living together, are dating or engaged, and are family members or people living in the same house together. And if these criteria are met, you are able to take out a protection order against any one of these members who may be abusing you. Now tonight we're going to hear from some stakeholders about protection orders, but before that we're going to take a short break and we'll be back with more after this. Welcome back. You're still watching The Womxn Show, and before the break we heard from some shelter managers who had been experiencing issues seeking protection orders within the justice system. Now we're going to be speaking to Cindy Msimang From the GRIP Mkhondo Women's Shelter in Mpumalanga, Cindy has only been in her position for 2 months now, but has already heard of several issues that women have experienced when seeking protection orders.
Hi, Cindy Siwe. Thanks so much for joining us.
Hi, thank you so much for having me.
Thanks. So, Cindy Siwe, we chatted previously, and you are a shelter manager and have said that from some of the clients that have come to your shelter, they have expressed that they've been having problems sort of getting and serving their protection orders. So I wanted to start off, before we go into the protection orders, to just ask, what kind of services do shelters offer to victims of abuse?
Okay, yes, I am a social worker and a shelter manager. So we provide sheltering firstly for survivors and victims of gender-based violence. We provide accommodation and food, shelter for a minimum of 1 day to a maximum of 6 months, provided depending on when or how long they need the shelter for. We also provide psychosocial support, therapeutic support, debriefing, vocational skills, which include maybe skills such as sewing skills, baking skills, computer skills, driving skills. We are all for women empowerment. So we believe that when they come in here, they should live here empowered, and they should not go back to where they were or go back and depend on the perpetrator. They should live here and go and make a living for themselves. So with the skills that we provide for them, they can be able to, for an example, with the sewing skills, with the COVID, they can take advantage of that, sew masks for COVID, and they can sell that and make a living out of that. And that's what we provide. We also link survivors to other stakeholders, such as Department of Social Development, the police station, courts, the municipality, and so forth.
Okay, thank you, Cindy Siwe, for that breakdown of services. Just to come back to connecting survivors to other services, you mentioned that you connect them to the police, that you connect them to court, and DST, but we know that the issue here sometimes is with protection orders, which involves both the court and the police. So can you tell us about how you assist victims with with these court processes and even with engaging with police?
Okay, with us at GRIP, we have a court friend or friend of the court who's there to assist when the victims go there to apply for protection orders. They provide them with support. We also provide them with food, because as you know, these processes, they go there at 8 in the morning and they sometimes come out of there late and they don't have food. So we provide food and water and juice. We provide support, because sometimes they go there, they don't even know the first thing about protection orders or the processes of the court. So the friends of the court, they give them counseling as to how, or the processes that happen throughout, what's done, what's to be expected. One of the things that's not done, they don't go in with them when they go to apply for the protection order, which is something that I feel should be changed, because when we say we advocate for them, we should be there to see everything through, because sometimes the victims, they don't even understand English, they don't understand some of the wordings, that they just agree to everything you say because you are the professional. So yes, we do provide court preparation services as well, where when the victims go to the court for to provide testimonies, we prepare them in terms of telling them that this is how the court looks like. You will be seated there. The magistrate will be sitting there. This is how you answer. And if you don't want to look at the perpetrator, you have every right not to look at the perpetrator. You just look at the magistrate. You answer as truthfully and as honestly as possibly as you can. If you don't remember, you have every right to say you don't remember anything. So those are some of the services we provide.
Wow, Cindy Siwe, thank you. I mean, for that breakdown, that is very interesting, and especially because it's also um, such a difficult process, and there's a lot of anxiety involved. And I know that not knowing what's supposed to happen or what your rights are, or what you can or can't do, just makes it worse. And then there's also what we've heard about is secondary traumatization. And part of the secondary trauma is when processes are not followed properly, when rights are violated, and possibly the women going through the system know there's something wrong, but they're not quite sure exactly what that is, or they're not sure how to phrase it, or as you say, they don't know, they're not comfortable questioning it because the other person has more knowledge or is in charge, which brings us to, you know, some issues that women have been having around getting protection orders and also having them served by the police. You said that you are in your position for, I think, just under or around 2 months now, and have already had several cases where women have had problems with protection orders. Could you tell us a bit more about those experiences?
Um, you know, with this secondary victimization, it's it's just kind of like I'm astonished. I have a survivor that I have, and she is abused by her ex-boyfriend. Her ex-boyfriend is a foreign national. She went to apply for a protection order, and she's victimized by the by the perpetrator. And then when she goes to apply for protection, the secondary victimizations she received from the police, it's I was shocked. She comes and she's crying. She's saying that they're laughing at her. What are you doing with a foreign national? And to my astonishment, she was like, even a court official, somebody who's, the high rank, even said those words to her, like, what are you doing with the foreign national in the first place? It serves you right. I mean, we are supposed to be protecting them. We are supposed to be fighting for these women. And then for them to be victimized by us, I was shocked. I was shocked. And it's not only her. There are a lot of women who are going through the same things. As you said, yes, I've been here for under 2 months, and already the problems that I'm facing with these protection orders are astonishing. They are astonishing. Victims have been told that they must go and search for the perpetrator themselves, and that the interim protection order would be cancelled if they can't find the perpetrator, and that they must wait for the perpetrator to attack them again for them to go and open a case if the protection order is cancelled. Now, how do you do that? I mean, some of the victims that I have, the survivors that I have, are here at the shelter for protection from the perpetrators. So how do you tell them that they must go and search for the perpetrator? Like one of my victims, she was attacked by the perpetrator twice when she went to look for her things she went to like collect her things. So the police, they didn't do their job properly. They left her there, and they said they are coming back. They actually just asked the brother of the perpetrator if the perpetrator's there, and the brother lied and said no, he's not there. And then they told the victim that, okay, we are coming back, we're just going to attend another case. And they left her there to collect her things. Unfortunately, the perpetrator was there, and he beat her up the second time. You understand? And I don't understand, how could they just leave her there without even checking if he's there or not? And this is some of the things that the police are not taking seriously. The one victim said to me that the police, yes, they go with her and pretend that they're going to serve the perpetrator the interim protection order. And right when they are about to reach the place where the perpetrator stays, they just say, go and serve and go and give your boyfriend the interim protection order. We're not going with you there. So these are some of the things that really mind boggles me as to if we're saying that we are advocating for the victims, are we really, really advocating for the victims, or are we protecting the perpetrators? What's really going on? Are we really advocating for them? What are we doing? Because now most of these women, they are like, no, if this is what's been done, then it's fine. Just give me the counseling that I need to heal the scars that I have. I'm fine with these protection orders. I don't want to do it. And some of them are even saying that this is why we don't even we open the cases, because we know that if we open the cases, then nothing is going to be done. Nothing is going to be done if we open the cases. Cases are withdrawn because of such incompetent police work. You know, I was watching this case. I don't know if you were following it. This case, I think this guy, it was on checkpoints, Fenyana something, who was harassing these ladies at the gym. And because of incompetent policing the cases, he received bail because the police were not doing the work that they should have done. That magistrate, he was so frustrated because everything was there, but the police, they just couldn't do their duties. So these ladies are saying that what's the point of us opening the cases and then the next thing, nothing is going to be done? It's better if we at least have a protection order. Then we know that they can't get to us with a protection order. But now we can't even get the protection order because the police are not even assisting us. The one lady lives, I think, in these rural areas around here, and she's calling me and she's like, Cindy, can you please assist me? We tried serving this guy the protection order, but he ran away. But now we have this tribal meeting. He is here. I'm trying to call the police, but they're telling me that they can't come. Can you please just get them here? Because the guy is here. I'm afraid. He's here. I have this interim protection order with me. I just need the police to come help me serve. And I had to call the police and beg them and beg them and beg them, please, the perpetrator is there. So these are some of the things that are just mind-boggling that the survivors are going through. And, you know, for you to tell a survivor to go and search for the perpetrator, it's, yeah, it's something else.
Cindy Siwe, thank you so much. I mean, that's all we have time for, but you've given us a wealth of information, and we really appreciate and thank you for coming onto the show.
Thank you so much for having me.
Welcome back. You're still watching The Womxn Show. Now, earlier this year, the Western Cape Department of Community Safety released a report on court watching briefs, where they monitored a number of court cases to see if processes were followed. They found 92 cases struck from the dole, 66 of them related to gender-based violence, 2 of which were related to violations of protection orders. Now we're going to be speaking to Minister of Community Safety in the Western Cape, Minister Albert Fritz, to hear more about how GBV cases are handled in the court system.
Minister, we're speaking today about the court watching briefs, and you or the department has identified a number of cases that were struck off the roll. But before we go into that, I just wanted a sort of short explanation about what is the court watching brief.
Thank you, Lenina. The court watching briefs we introduced a few years ago in the Western Cape, where we actually found, and we could never understand why cases were withdrawn without any rational explanation. And what we then decided to do, and it's before my time, I was at that time in social development, but what I decided to do was to have advocates attend court cases where specifically gender-based violence cases or any other case where we just thought there was a massive injustice or by not getting this case through or make sure that people get justice when that is kind of in question. And magistrates and prosecutors became aware that we had people sitting in court watching the case. And we have, there's a very senior advocate that we have in our department who used to be with the Department of Public Prosecutions. And everyone knows him. Most of them came through his hands, as prosecutors. And so what we have found, the quality of cases and the way people make extra effort to get evidence to make a case actually go through the court and that they don't just get withdrawn. We saw that improving. We were doing so well that during the previous period, we had a number of policemen disciplined for making cases and dockets disappear, but also the level of investigation to make sure that you are going to get a conviction. That was also under the microscope. And so what happened? Why wasn't a cardinal piece of information or piece of evidence presented to the court, even though it's in the bag, the evidence bag? That kind of stuff we looked at. And I must tell you, we had an amazing success, so much so that the National Minister, Minister Beck, insisted that we also have a workshop in Cape Town where all the 8 provinces came, and that whole methodology, that the whole tool to make sure people get justice, that be expanded to all other provinces. And now it's in every other province. But I want to say it's really an amazing tool because all we do, it's a kind of a tool of accountability. The ordinary member of the public can have a tool that holds the prosecutor and the police investigating officer accountable. And I think that's the important point about this.
That does sound amazing, Minister. Thank you for that explanation. I wanted to ask, what does it mean when a case is struck off the dole? Is that just the end of it, basically?
No, that's the, in law, the good thing with that is a case is always temporarily withdrawn because of the 2 issues. Either if the docket disappears, there's a way of reconstructing that docket. So it will be withdrawn. And it's a temporary withdrawal that can always be reinstated. And the second issue is when people come constantly, the police, the investigating officer come to court and informs the court and the judicial officer that, the investigation is incomplete, that they're still busy with the investigation. And I mean, if you do it for 10 times, the Constitutional guarantees a fast and a speedy court procedure for every accused. I mean, Section 35 of the Constitution speaks to a speedy trial that an accused is entitled to. Unfortunately, our criminal justice system works a bit slower, but for our ordinary people, that lady in Kuils River, the lady in Hanover Park, the lady in Manenberg, in Mitchell's Plain, who after having the police had the man arrested, everyone saw him killing someone or stealing something or doing something. That man, tomorrow he walks back in the street. And one of the big complaints people are saying, why is this man back? How could they give, apart from bail is something else. Many times the court find that this person, there's a reasonable possibility that he will get back to court to attend his hearing. That people are so upset and sick and tired of seeing the perpetrator or the alleged perpetrator. I must use the word alleged perpetrator. After having allegedly committed the crime, he then walks back on the street. And many people, I don't necessarily, I think in law, bail is a privilege, but it's also something that a court must have that ability to decide, not people from outside. But how can it be possible when someone have committed 3 murders before and then he goes to court and they give him bail again and the prosecution does not object to that bail? That I don't understand. And we have seen many cases now where people who've been on bail come out, commit another murder and then get caught again, and then the court says, no, you can't go. I can't believe it. When after you have committed the murder, you get bail again, you do another crime like that. and then the third time around they wouldn't let you out. I just don't understand that. So, but I don't want to interfere with the independence of the judiciary. I think that's an important principle we must say. I think we need to just sometimes to ask, the community's interest, and the interest of justice is always, those are always some kind of the, factors that are taken into consideration when applying, for instance, or bail or these other cases that's around. Yeah.
Yes. Thank you, Minister. And I have to say also, with cases being struck off the roll, then those perpetrators are just free basically to go and walk around. But I wanted to ask if we've seen a high case from the cases that were struck off the roll. 66 of them, which is quite a high caseload, were GBVF, gender-based violence cases, domestic violence cases, and I was particularly interested to see that 14 of them were rape cases. Now we know that in South Africa we have a very low conviction rate compared to the amount of cases that are reported. And do you think that this is a reflection of that low conviction rate?
Yes, so all of it. I mean, I must say to you that same day when we released the cases that's been withdrawn for dockets that disappear and for incomplete investigations, on that same day, the Portfolio Committee of Police had a hearing on the forensic services that's near collapse. And I'm sorry, I'm not pointing fingers now. I'm just stating the facts. And so, if you have a forensic services that's not functional, that is not because there's incompetent people, they're excellent. I think we have one of the best forensic services in the, I think in Africa and in some parts of the world, we have the best. The problem is many times the required substances and chemicals that's needed to make it operative and make it fully 100% operational. That's the problem. So many times our rape kits that goes for forensics, there's a huge delay in that. The court would many times hear that, oh, that's not back, that the backlog at forensics impact on the way the court runs. And at some point, the magistrate takes a decision where he says, sorry, I can't postpone this case again. So that's one factor. The other factor that's frightening and that's worrying is the fact that dockets can still disappear in this 21st century with high digital kind of mechanisms and electronic mechanisms. And I remember many years ago, I used to be with the Office of the Inspecting Judge. And in that office, I remember sitting on case flow meetings on a Friday where we discussed the electronic, capturing of all dockets precisely so that it can't disappear. Now that was literally more than 20 years ago, So the question I'm asking, how can the docket still disappear? The physical docket can disappear, but surely we have an electronic copy of that.
Yeah.
And those are part of the stuff that we I spoke to the Premier, and we also spoke to our commissioners around. How is it possible that this can happen? But it's frightening that it can still happen, that I can pay a police officer 10,000 Rand for a docket to disappear so that my case can be withdrawn. Although temporary, because we can reconstruct a docket. And then the last point I'm making is the issue around investigations that's incomplete. Now, I must also immediately say, Lanina, that our detectives are under huge pressure. What we're not talking about, and this is another problem that we have, and you can go to Sanja Bornman, one of our shelters, you will hear from them how many women on a Friday, Saturday come and lay a charge against the husband or the boyfriend or whatever, and on Monday withdraw that case. These cases don't refer to that phenomenon. I just want to make that clear.
Yeah.
But that's another issue that we need to discuss and really sensitize our women to really, when they lay the charge, and I'm saying it, it's because also the economic dependence of women on men. So, oh, but my husband, he has a job, or my boyfriend got a job, he's the one who brings the income. That's a pity. because by Monday that guy's again, and next weekend he drinks again, and the whole violence starts all over again. So, but these cases that we're referring to are pure cases where the doctor disappeared or an investigation was incomplete.
Yes. Minister, I want to ask, so, and there are lots of cases like that. I speak to women all the time who have frustration with the system and on many levels. You know, sometimes it starts with not being taken seriously or not being treated with dignity when they are going through the justice process.
Yes.
The other one is also not being kept updated. And we know that a lot of,
Yes.
if we wanted to say, and we wanted to look at rape cases, for instance, that a lot of women research has shown drop the case because it takes so long. And I think those are because of the delays that were mentioned, whether it's forensics or whether it's the investigation. But with women and people who are directly experiencing these things in court. So for example, it's my case. And I've come to my third or fourth hearing now. The docket's just never available. As a citizen and a client of that system, what actions can I take around that? Instead of just accepting that this is struck off the roll now.
Yeah, that's why one of the issues that we want to do as the Department of Community Safety is to, in a way, try and be the voice of that lady who is so frustrated. And I promise you, I speak to many cases. I mean, I have a number of people on my WhatsApp group whose sons were murdered a few years ago. They were murdered. One woman is so badly affected by it that recently she was taken up into a clinic for psychiatric assistance or treatment, and we have a court watching brief on her case. The point I want to make is the same with those rape cases, where you just don't, and every time you come, or you have to sit in the same passage with some of the perpetrators or the alleged perpetrator. All of those kind of very, it sometimes appears to be small, little issues that we can just get right, as a criminal justice system. Those are the issues that really impact on people and on victims, because many times, and I'm saying this with absolute respect, I'm a person who honestly believed in the Constitution, but many times it appears as if the perpetrator have more constitutional kind of rights than the victim, the person who's really been done in, who's really been done an injustice. And therefore, our court watching brief system is trying to be the voice for that woman, who's not legally trained, that man who's not legally trained, who don't understand the criminal justice system, to try and be a voice, but in the process to all the time keep them informed so that they get empowered, so that they can start understanding the criminal justice system a bit better, so that they can feel a bit better in terms of, okay, this wheel is turning long, but justice will be served eventually.
Welcome back. You're still watching The Womxn Show, and we're speaking about domestic violence and protection orders. Joining us now is Sanja Bornman, who is from Lawyers for Human Rights, and she's going to be speaking to us more about this issue, as well as certain amendments that were proposed for the Domestic Violence Act. Welcome, Sanja. Thank you for joining us.
Thanks, Lenina. Thanks for having me.
What are protection orders and what purpose are they supposed to serve?
Lenina, a protection order is a special protective mechanism that is established by the Domestic Violence Act of 1998. And really what it is a civil court order that has criminal law consequences attached to violating that order. So what it means is that a victim of domestic violence can approach the nearest magistrate's court and make an application for an order, a court order, which states that the abuser has to either stop doing something or start doing something in order to put an end to the abusive situation that the victim is experiencing. So a lot of folks think that you can get a protection order at the police station. This is not correct. And police stations will often refer clients to the magistrate's court to say that, you know, we can't help you, you first have to go to the magistrate's court. Now that also is not strictly speaking true, but what is true is that you do need to go to the magistrate's court for this protection order. There will be a special division where domestic violence protection orders are processed and issued, and you have to fill out an application form that describes your personal circumstances, your personal details, and based on that, a magistrate must consider your application and decide whether to give you this protection order or not.
There have been complaints from women, from victims. I mean, there have been media reports. There's just been a lot of narrative about processes not following, about women struggling to serve protection orders, possibly not getting adequate assistance at courts. And so, and this is leaving many women at risk, even though they are seeking help. So I wanted to ask whether you can give us some examples of some of the issues or cases that you have seen or heard about, and what these issues or problems could look like.
Looking at the situation overall, what we see most often when clients approach us for assistance is that the process it has not been properly explained to that person. So they will arrive at our office with, for example, an interim, which is just a fancy legal way of saying an in the meantime temporary protection order. They will arrive at my office with a temporary protection order, which by the time they come to me has already expired. And at that point, it becomes clear that no one explained to them that this is a temporary document, that it does have an expiration date, and what you need to do to make sure that it doesn't expire. And I'll take you through what I consider to be the 4 sort of goalpost steps that a person should be looking out for when they're making their application. And really making the application, filling in the form is really only step 1. In addition to that, we find that there's a lot of false information out there about how this process is supposed to work. There doesn't seem to be consistency in the advice given or the explanations given from one court to the next. There doesn't seem to be a clear enough understanding of how these things are supposed to work from a legal perspective in terms of what the law says. At the court level, when you're discussing with your application with a court clerk, for example, but also at the police station. So it's very dangerous to give a complainant the wrong information because the wrong information can derail the entire process and defeat the purpose of having this protective mechanism in our law to begin with. And you know, we see a lot of misinformation and misunderstanding around things like urgency, things like imminent harm, what constitutes imminent harm, a misunderstanding around how the suspended warrants of arrest that you get with your protection order, how do those work? What are they for? Who should have them? And so it really, I think the key concern here is that what you read in the Domestic Violence Act is not what is being implemented on the ground. Often there are gaps, often there is, as I've said, misleading evidence, or not misleading evidence, misleading explanations to clients who want to make use of the system. And often we also see a very generic approach to how these forms are filled in, the application forms. And applying for a domestic violence protection order is a highly personal thing. The whole point of having an application form that has multiple different things that you can choose for your protection, that has a fairly large space for you to explain what your personal situation is. The point of having that is to make sure that your protection order is tailored to fit your life and your situation, the unique aspect of your case, because every person's case is different. And unfortunately, too often we see a very generic approach where it seems as if a clerk of the court has assisted an applicant to fill in the form and has just sort of ticked a range of boxes on the form without spending sufficient time figuring out what that person's circumstances really are and how to tailor that application to suit their particular needs. Another issue that we face is very often there is a misunderstanding around, as I've indicated, the temporary orders, the interim orders, and the purpose that they serve. So when you apply for a protection order, you need to follow or think about the process in 4 steps in order to make sure that you don't miss things. So in our mind, step 1 is really filling in the application form. And this really entails a thorough understanding of what that form is asking for, the information that it is asking for, and what are the implications of how you give that information. So, for example, there will be a short little area on the form to describe the nature of the abuse and what exactly is happening in the home. And it seems that a lot of applicants feel constrained by that short little space that is given. And they're not aware of the fact that they can actually say a lot more. You just need to do it maybe on a separate piece of paper, and in the little box say, refer to the attached affidavit or written statement that sets out all of the facts. And so because folks see this tiny little box, they are guided by that in terms of how much information they provide. And that is a mistake, because a court needs the maximum amount of information about what is going on in your domestic relationship, so that it can apply its mind to the situation and fully appreciate what it is that you need as a complainant and as an applicant for this domestic violence order. So step 1 is this applications process, and it really requires fully understanding that form. And if there's anything on the form that you do not understand, you need to seek advice or ask questions about it.
Thank you so much, Sanja, for that rundown. And just on your last point, you know, I've spoken before, I've interviewed before actually a peace officer who assists women with protection orders. And one of the things that he often says to victims of violence is, don't be afraid to write down exactly what happened, exactly what was said. And it's actually very important to use what I could frame as the crude language. So when we're talking about verbal abuse, the swear words, and I say this because, you know, we feel shy and ashamed, and, you know, we're going into a government building, or we're speaking to police or social workers or clerks of the court. And so he said, you know, people don't want to say those things. Would you agree with that statement?
Lenina, I would absolutely agree with that statement. I think it is crucial to put the maximum amount of information before the court and in your statements to the police, because they don't know your situation the way that you do. You are the one who knows exactly what happened, and you need to give them that information if you want them to take action. And it is completely understandable that a person doesn't want to say those very personal, intimate things, but unfortunately in this process it is necessary to do that, and a person should not hold back. I always encourage clients to go into a fair amount of detail, including dates and times. Those are very important. Names of third parties who might be involved. Really as much detail as you can provide. And because we are talking about domestic violence, it is important to say the exact words that were used. If we're talking about verbal abuse or psychological abuse, or to explain exactly how physical violence was inflicted and what kind of wounds a person may have suffered or what kind of injuries. And of course, the fact that you don't have any physical injuries at all should not stop you from getting a domestic violence protection order, because the law recognizes that domestic abuse is not only physical abuse. So a lot of us have this idea in our head of, you know, a woman with a black eye and sort of bruises on her face and so on. But that is not necessarily how the majority of domestic violence cases play out. And it certainly doesn't make them any less damaging to an individual or to a family or even to a community. So that is why the law recognizes physical abuse and sexual abuse, which are the ones that we all immediately think about, but also emotional abuse, psychological abuse, economic abuse, which is something that few people understand they can actually get a domestic violence protection order for. And so it is critically important to tell the court and the police exactly what is going on in your home.
That brings us to the end of our show. If you are experiencing domestic violence and need assistance, you can contact the GBV hotline on 0800 428 428 or send a please call me to *120 *7867#. I'm Lenina Rasool. Thank you and good night.